Good evening, everyone. My name's Lydia Slee, and I'm a family barrister at 42BR. And also presenting this evening, we have Philippa Thomas, another family barrister at 42BR. We both specialise in care proceedings, and we would like to talk to you this evening about the proportionality of care orders, particularly in light of the case of HW. Before we start our talk, we would like to just remind that this is our fourth seminar within this autumn-winter series. And if you'd like to register your interest for any further seminars, please visit the website or contact the clerks, and they will be able to guide you to book slots for further sessions. So looking at the slides, I'm going to start with the first tranche of the slides, and then Philippa will take over. But just to give a bit of background in relation to the case that we're going to talk about, we will start with some facts. But it won't come as a surprise. We feel when we talk about this case that we're actually stepping back in time, particularly to 2013, when, of course, we will remember the cases of Re-B, Re-BS, and Re-G, which we will touch upon. But looking at the current case of Re-HW, you will see that in a nutshell, this case from the Supreme Court really concerns an appeal that concerns 3 children who are referred to C, D, and D. There was also a 4th child who was subject to care proceedings, but was not subject to the appeal, and that child was known as F during the proceedings. The children were part of a sibling group of 6. There were 2 other children, child A and B, who were both adults at the time of the proceedings, and both A and B lived independently. At the time of the appeal, C, D, and E lived at home with mother and father to F, and you will see from the case that C and D were indeed full siblings, and the other children had different fathers. The case concerns long-standing local authority involvement. In fact, it stems back to mother's involvement when she was a child herself, and sadly she suffered sexual abuse by E's father, and there were concerns relating to sexual abuse and neglect. There were previous proceedings in 2012, and that was when there were allegations that E's father had been found in the family home. During those proceedings, the children were not removed, but A, the child A, who was a child at the time, was made subject to a care order. In addition, in relation to the other children, there was a supervision order and a non-molestation order, and following cooperation with the family, the local authority closed its case in 2019. The current proceedings that the appeal deals with were initiated in March 2020, and that was instigated as a result of A's behaviour, child A's behaviour, whereby he was not permitted to be left unsupervised with the children. There was an allegation where adult A was said to have sexually abused child E, and therefore the local authority issued an application to remove all of the children from the care of the parents. That application was refused, and protective measures were put into place, including an interim supervision order and a non-molestation order preventing A from going to the family home. Matters proceeded down the line of a fact-finding hearing, and the court determined that E was sexually abused by mother's older child A, with some additional findings, but the allegation in relation to the sexual abuse that was found was a single incident whereby mother and father of child F were distracted by dealing with an injured dog within the family home. A 6-day welfare hearing followed, whereby the local authority sought care orders, and the plans for those children were that they were going to be placed in foster care separately from each other, and therefore they were going to be removed not only from their parents but from each other, and the contact arrangements were proposed at 6 times per year. The judgment was given on the 26th of July, and the judge at first instance approved the care plans of the local authority by endorsing the plan to remove the children and for them to be placed in their separate foster placements. The judge did adjourn the case in respect of child F for further assessment, and therefore that was the reason why child F did not form part of the appeal. There were the first appeal was to the Court of Appeal, and you can see on the slide the basis upon which the parents appealed that, and that was on the basis that the judge erred in law by failing to consider the proportionality in respect of care orders and failed to undertake the balancing exercise that should be undertaken. The Court of Appeal upheld the judge's decision, and in fact the appeal can be found at citation 2021 EWCA Civ 1451, and that was the appeal was refused by a 2-to-1 majority, and the care orders were affirmed. The parents continued, and they appealed to the Supreme Court on the same basis upon which they appealed to the Court of Appeal, and the Supreme Court in fact identified 2 questions when looking at the appeal, which we will deal with in turn shortly. But in a nutshell, the Supreme Court, as you all know, unanimously allowed the appeal, and the matter was remitted for a rehearing to be undertaken by a different judge, and with the observation that the care plans will need to be scrutinised in accordance with the decision that the Supreme Court gave. So the Supreme Court identified 2 questions, and we have put those questions on the slide. The first question is in fact broken down into 4 areas that the court would need to look at, but that is in a nutshell the proportionality question, and that is as follows. Was it necessary as a matter of law to assess the likelihood that if left in the appellant's care, A, the children would suffer sexual harm, B, the consequences of such harm arising, C, the possibility of reducing or mitigating the risk of such harm, and D, the comparative welfare advantages and disadvantages of the options presented. And the second question is the balancing question, and in a nutshell, it's the question as whether the judge erred in law by failing to make any proper assessment of those matters. So turning to the proportionality question, the court held that all 4 of those questions needed to be answered in order to determine the issue of proportionality, and that was required under the legislation. What we then go on to look at are the how those questions need to be considered, and the questions 1 and A, so the first 2 questions 1A and B, clearly deal with the harm and the risk of harm and the likelihood of that harm, and it will be evidently clear that those questions are interlinked. And what the court must do when looking at those questions, that the court must refer to the welfare checklist when forming part of the holistic evaluation. And this slide simply reiterates the requirement under the legislation in order to look at the test of necessity, but also to consider the least interventionist orders and to consider all of the orders, all of the range of powers available to the court. And when doing that, that's when question 1C really comes into play, because that question that the court is required to look at is in relation to mitigation and what measures can be put into place to reduce the risk of harm or the harm that may be suffered by way of protective measures and any safeguarding measures. In this case, they refer to mitigation, but we clearly and readily know the terms of protective measures and safeguarding measures, and that not only includes the least interventionist orders under the public law orders that are available, but also in terms of any injunctive relief or private law orders that offer protection for the children. Looking at the next slide, in order to answer the proportionality question, this is when we do jump back to 2013, where the court reminded itself of the test of necessity in relation to care orders and the advantages and the disadvantages that need to be weighed up when looking at each available option. And in the case, the previous authorities, RE-B, RE-BS, RE-G, are all referred to with the Supreme Court endorsing those approaches and those principles within the case, within the appeal. And what is crucial, because automatically when we're looking at placement orders, we think of RE-B, RE-BS, but the Supreme Court endorsed the fact that care orders need to be given the same amount of scrutiny in terms of assessing the issue of proportionality and indeed the balancing exercise. And particularly in this case, because the Court of Appeal, that the Supreme Court mentioned that the plan that the local authority were advancing was almost as far reaching as a placement order, because the local authority was seeking permanent orders to separate these children, not only from their parents, but their siblings as well. And that was ultimately going to break up an existing family unit. Philippa is going to take over from the balancing question going forward.
So obviously this has left all of us wondering how this is going to impact and the balancing question. And so what the court was saying clearly was there needed to be a proper assessment of all the possible options when deciding what order should it make. The Supreme Court considered, obviously, that the judge at first instance, whilst giving a really comprehensive judgment of all of the factual backgrounds, the basis of why the local authority intervened, the evidence and the legal test, the issue that they needed to consider was whether, in fact, the judge fell into error when deciding upon the welfare disposal and the necessity of that order. It was held, obviously, that the judge did not expressly weigh up all of the least interventionist options, as Lydia's already set out, such as lesser protective orders. So they reminded themselves of the case law of RE-G 2013, confirming and accepting the standard for the matter in which a contemplated child protection order must be tested against the requirement that it be necessary and proportionate. And I know we all spout those terms all the time when we're in court, but this is really setting down again that the court should be satisfied and has to be satisfied in their judgment that they have explored all of those options. The judicial task is to evaluate all of the options, undertaking a global, holistic and multifaceted evaluation of the child's welfare, which takes into account all the negatives and the positives, all the pros and the cons for each of those options. And essentially, what is required is a balancing exercise in which each option is evaluated to the degree of detail necessary to analyse and weigh its own internal positives, negatives, and each option is then compared side by side against the competing option or options. I know that most of you probably on this have a regular argument with local authorities as to alternative care plans. And ultimately, this is the case that you need to use to say that they should be providing those alternative care plans to the court. So the decision of the Supreme Court was that the decision was insufficiently founded on the necessity analysis and comparative balancing of all of the options, which include an inadequate assessment of measures and options which may mitigate against the risk of harm if the children were to remain at home. The reasoning behind that can be summarised as follows. Reliance on the local authority evidence regarding the options would not have sufficed due to the lack of analysis of the options and mitigating measures. The judge failed to mention the efficacy of injunctive measures. The judge did not deal with section 13G of the welfare checklist. And the judge did not fully recognise the impact of the plan for permanence for each of the individual children. There was a lack of comparative analysis of all of the available options by way of evaluative and holistic assessment. Notwithstanding the risk of harm that had been identified, the judge failed to evaluate the extent of the risk of significant harm, nor any means of mitigating from that said harm. There was no comparison or balance of the harm if the children were to remain in the home against being separated from their parents and indeed their siblings. And the judge didn't address why the emotional harm that each of those individual children would suffer by removal was proportionate and necessary by the risk of sexual harm when no such harm had occurred since the implementation of the protective measures, the ISO and the non-molestation order that had been made in 2020. And so in considering all of those issues, as we say, ultimately, the Supreme Court said that the judge needed to rehear the matter. And in considering that, obviously, we need to look at certain other cases. And one of those is Re-D, a child and placement orders, which was also in 2002. So the recent decision in that case was highlighted and underlines that a decision leading to adoption, bear with me 1 second, sorry, my screen's gone a bit funny, or an order with similarly profound effects requires the rigorous evaluation and comparison of all the realistic possibilities for a child's future in light of the court's factual findings. Adoption can only be approved where it is the child's lifelong best interests and where the severe interference in the right to respect family life is necessary and proportionate. The court must therefore evaluate the family placement and assess the nature and likelihood of the harm that the child would be likely to suffer or has suffered, and the consequences of that harm arising, or the possibility of how that could be reduced and those risks mitigated. It set out that it must then compare the advantages and disadvantages for the child of that placement with the advantages and disadvantages of adoption and any other realistic placement outcomes short of adoption. The comparison will inevitably include a consideration of any harm that the children would suffer in the placement, family placement, and any harm arising from them being separated from their parents, siblings, or in fact any other relatives in who they were currently placed or could potentially be placed. It's only through that process that the evaluation and comparison that the court can validly conclude that adoption is the only outcome and can provide for the child's lifelong welfare. In other words, it is necessary and it is proportionate. And as has been said, more centrally, to borrow from HW at paragraph 51, the judge telescoped the process. And so, in fact, there was then another case in Re-C, and this had similar backgrounds, but it was a child who had severe medical needs. And in fact, C was the youngest of those children. And what came from that is that the court decided that an adoption, a placement order would be made. They were successful on appeal in that it hadn't been that the court had considered at first instance the other options, and one of those other options was for child C to remain with Mr. and Mrs. D, who could care for her long term, and hadn't weighed up the pros and cons, essentially, of long-term foster care with carers who were willing and committed to care for that child. It boiled down to, in that case, financial, as it always does, and that they simply couldn't afford to adopt or to keep child C if the funding that the local authority were offering was withdrawn. And so in that case, it was also agreed that the court needed to look at those other options. So the impact, essentially, of this on care and placement orders, it's too early to evaluate the impact upon the care planning, or is it? This case has now been around for over a year. And I have to say, in the area where I practice mainly, I don't think it's been taking much heed of. But the issue is the fundamental need for the court to provide fully reasoned accounts, comparing the options side by side, explaining how all of the potential options and orders may mitigate risks to the children and welfare when determining the necessary and proportionate orders, failing which the judgment is flawed. So in practice, the principle applied to all applications in respect of care proceedings at final disposal, not just in respect of adoption. And the impact of permanence under a care order must be recognised and addressed. The local authorities must, and this isn't we don't agree with that, they must provide evidence of all the possible options and measures and possible orders to mitigate the risk of harm, irrespective of its plan. These options must be scrutinised, ensuring that the evidence is tailored to the case rather than the standard generic analysis. There must be assessed compliance and the effect of measures during the interim stage, and they must scrutinise the plan for permanence. They must look at the separation of the siblings, contact arrangements, particularly when considering emotional harm to the children if separated from their parents and their siblings, and evidence from primary material may be of probative value, as well as relying on formal assessments. And this is ultimately where it really helps to have social workers and guardians who are involved in the care and have a good relationship, because they will be able to provide assistance as to the impact it will have on the children in particular. Do not, and what we say is, accept the usual stance that the local authority put forward, that it is not their care plan and therefore they are not going to provide an alternative care plan. The law is clear. The court has to be provided with alternative care plans that are detailed and need to address how risks could be mitigated within the home. If necessary, at an early stage, when you are considering instructing experts such as ISWs and psychologists, ask them that exact question. It goes further than the sibling assessment and it looks at the realistic options as to how any risk that has been identified by the experts in the court can be mitigated. And the court needs to address these issues fully, and there needs to be a move away from the norm that resources will not allow children to remain within the home if the risks can be managed. And I say this as all of you have probably come up, those who are here for the local authority against management within the local authority, and those who represent parents and children, is that it will be a resource issue, that they couldn't complete daily visits for the first few months to make sure that that's happening, that they couldn't provide additional support services. You also have to allow for adequate time for submissions to address these legal issues. I know we're all put under pressure when we're in court to be as quick as we can, and submissions aren't necessarily given as much time as they should be, but we have a duty to make sure that those legal principles are outlined to the judge. And I know going forward, I certainly will be making a point of that. And also allow sufficient time for the judgment to address the risks, how the risk can be mitigated, the comparison of the harm that should the child remain at home, and the harm of being removed, and that any of that harm or removal is proportionate and necessary. And of course, this will have an impact on the overall time estimates within care proceedings, but they're all issues that need to be adequately and carefully looked at. So in conclusion, if you've read the case, and I don't necessarily say you have to read all of it, but obviously by way of update, there was many from our chambers who were in this case, and in fact it has gone back down to retrial and came back up to the Court of Appeal again, and I can give you that reference when we email the link later if you wish. But ultimately, this is a case that is still ongoing and is still many issues that have been highlighted. Lydia and I have spoken about this in Kent where we practice, and I have to say the judges are not implementing this case law, and they're not being strict on making the local authorities look at the alternatives. And that's something that I suppose as all practitioners we should be making a point of asking the judges to do so. And if it's not set out clearly in the judge's judgment, that in fact we should be asking for that clarification and making sure that we're protecting all of the parties' interests in making sure that that's clearly set out in any judgment that is given when there is separation, even if that's with adoption, long-term foster care, or in fact with family placement, to ensure that contact and that ongoing family relationship is protected. So that's the end of our seminar. We're more than happy to take some questions if there are any.
As of yet, I don't think there are any questions, but if any do arise, then please feel free to contact either us directly or via Sophie, who I'm sure will be willing to send the questions on to us.
There is just something in the chat, Sian. It's really nice to see that. It's good to see that you are using that with the courts in your area. And I'd be interested to know what the judge's responses are to you if they don't address it. But I know for definitely in Kent and London, it's not something that comes up that often. So in conclusion, I just wanted to thank you all for attending. Any unanswered questions, if you do have them, oh, there's something popping up in the questions and answers, we will try and deal with those. Oh, okay, sorry. Can I just check, the LA need to file both a care plan with their proposed care plan and then an alternative? Well, in fact, it should be set out in the care plan. There is, in the area that I practice, they have this lovely table that they potentially say they look at the alternative care plans. And in fact, it doesn't. It just says the reasons why and the pros and cons. Very clearly, I'm normally spouting on about what support would be in place for a parent if the court didn't make the orders. But in fact, it should become the norm that the local authority are looking at all of this. And in fact, you can insist on that. And if it becomes an issue where the local authority are refusing to do that, then you could get the judge to ensure that they file a separate document, which could be just to address those issues as to what they feel support would be in place to mitigate those risks. In terms of, so I'm not 100% sure on where exactly the children are. However, I do know that the adult children are in further education and doing well. And in fact, some of those children are now adults. Marissa, yeah, it should be set out, but it very rarely is to a comparison level as to what the care plan should be. If I stop that, and as I say, I will try and answer any more of those questions. Again, reminding you that this has been recorded. It will go up onto our YouTube channel, and so if there's anybody that you know who hasn't been able to join today and can watch that later. The next seminar in this series is on the 14th of December. That will be the fifth of them. It's First Appointments, Getting Your Ducks in a Row by Hannah Cox and Krishnal Patel. And ultimately, that will be setting out on how FDR's seminars given earlier in the year, how they can be accelerated, the procedure, identifying when Part 25 applications or intervener issues arise, and ensuring you are up to date with the latest good practice guidance. So that concludes our seminar. Thank you very much.
Thank you very much.